I'm Scott Hervey with Weintraub Tobin.
And I'm Josh Escovedo with Weintraub Tobin. The Supreme Court has granted Jack Daniels' petition for certiorari and agreed to hear the trademark infringement dispute over a parody toy called Bad Spaniels. That's what we'll be discussing on this installment of the briefing by the IP Law Blog. Months back, we discussed the dispute between VIP Products LLC and Jack Daniels over VIP's spoof dog toy called Bad Spaniels, which mimics the well-known Jack Daniels Old Number 7 bottle with dog jokes like the Old Number 2 in place of Old Number 7 and the words on your Tennessee carpet instead of Tennessee whiskey. While many of us may have found the parody humorous, Jack Daniels did not. It sent a cease and desist letter to VIP Products, which ultimately resulted in a lawsuit being filed. The district court ultimately granted summary judgment to VIP Products under the Rogers test from the Second Circuit, which attempts to strike the balance between trademark rights and free speech under the First Amendment. Under the Rogers test, if the use has artistic relevance and is not expressly misleading, there is not infringement. The district court found that VIP Products satisfied the test and dismissed the lawsuit. Later in 2020, the Ninth Circuit recognized that the Bad Spaniels silly squeaker is protected by the First Amendment and affirmed the decision below.
That's right. The Ninth Circuit went so far as to say that the Bad Spaniels dog toy, although surely not the equivalent of the Mona Lisa, is an expressive work. Of course, Jack Daniels was displeased with the district court and the Ninth Circuit's ruling and petitioned the Supreme Court for review. The Supreme Court ultimately granted the petition over VIP Products' argument that it should not do so. VIP argued that it has never sold whiskey or other similar products and has never used the phrase Jack Daniels in any way, and that it had simply mimicked the iconic bottle to ensure that people would get the joke. According to VIP Products, Jack Daniels just has a problem with the balance that Congress and the courts have struck between trademark rights and First Amendment rights, and that the Ninth Circuit's decision was manifestly correct. But the Supreme Court felt compelled to take up this issue.
The issues before the court are whether humorous use of another trademark as one's own on a commercial product is subject to the Lanham Act's traditional likelihood of confusion analysis, or instead receives heightened First Amendment protection from trademark claims, and whether humorous use of another's mark as one's own on a commercial product is non-commercial and thus bars, as a matter of law, a claim of dilution by tarnishment under the Trademark Dilution Revision Act. It'll be interesting to see how this plays out. Jack Daniels is supported by several amicus briefs, including that of the International Trademark Association, which has argued that without the court's review, the Ninth Circuit's view threatens trademark owners' ability to police their marks and protect consumers. And of course, VIP Products is not without its supporting amicus briefs either.
There are competing interests on both sides of this case, as you would expect with a case that has made its way up to the Supreme Court. Irrelevant of which side prevails, I'm sure the case will provide us with a clearer answer concerning the appropriate balance between First Amendment protections and trademark protections. But Josh, I find it interesting that Jack Daniels, as part of the question certified for the court to review, did not challenge the depiction of the squeaky dog toy as an expressive work. As we know from our coverage of the Vans case, there is a tension between what is and what is not an expressive work for the purposes of the Rogers test. One would think that Jack Daniels would have taken the opportunity to present this issue also for review to the court.
Yeah, I think that's interesting, Scott. And in fact, that's exactly what the International Trademark Association covered in its amicus brief. Essentially, what they said was the court needs to address and create essentially a dichotomy between traditional expressive works and things that may be more functional in nature, such as the shoe in the Vans case, or perhaps a squeaky dog toy in the VIP Products case. But, in my opinion, I don't know that the court should draw that distinction. And again, I'm just a lawyer who argues the law. I don't make the law. I'm sure the justices will find the appropriate balance here. But in my mind, what's expressive and artistically relevant varies from one person to another. I guarantee that you and I could discuss what we think is artistically relevant or expressive, and we'd have different opinions. I just don't really think that is something for the court to decide, but we'll see what they do with it.
Yeah. I mean, taking the opposite point of view, remember in the VIP case, they still have another argument that their use is not trademark infringement, that there would be no consumer confusion because it's a parody. I don't know that we ever actually got a answer to that because of the application of the Rogers test and the quick win that VIP Products received at the district court and at the Ninth Circuit. So it's not as if trademark owners, it's not as if third parties who use a third-party trademark in a non-trademark manner, in a manner that does not create either consumer confusion or dilution, it's not as if that defense doesn't exist anymore. It still does. This Rogers test provides an additional defense for that type of use. And maybe there is some value in drawing a line between traditional expressive works, because that's what Rogers versus Grimaldi was all about. It was about I believe, a motion picture, versus functional expressive works like the shoes in the Wavy Baby of Vans case. And also, I mean, maybe the court might address the level of artistic relevance that's required. Maybe they might find that the Honey Badger case was wrong when it said that the level needs to be just 0. Or maybe it wasn't the Honey Badger case. I can't remember where it was that the court said that it needs to be just 0. But I know that in the Honey Badger case, the court started to have some issues with that. We'll see, right? I mean, I have a feeling, I believe that the Supreme Court can address any one of these issues, even though it wasn't any of the questions on which cert was granted. We'll see. It definitely will be interesting, and it will definitely shape one of the tests that we have seen frequently applied and raised in our over 100 episodes of the briefing that we've covered to date.
Agreed. I think this is much needed clarity, irrespective of whether I think this should play out in favor of VIP or Jack Daniels. The clarity is necessary because, as we've seen and as we've covered over the last 12 months, there's a lot of litigation involving these issues involving parody and things that are permissible under the Rogers test in its current form. There is a need for clarity, and that's why the Supreme Court is taking it up. So, right. It'll be interesting, and we'll keep an eye on it. I'm sure we'll cover it very closely.
Yeah, we will, because it's extremely important for a number of our clients, for certain. So, well, thanks, Josh, for bringing this to our attention. Another very interesting topic.
Thanks, Scott.
Thanks for tuning into this installment of The Briefing by the IP Law Blog. Please remember to subscribe to our podcast and give us a 4-star review if you would. If you're interested in more content like this, well, we have a lot of back episodes, and you can always visit us at theiplawblog.com.